done, and it's oftentimes the people that we're dealing with are highly emotional because a relative is going into a nursing home. So that's one of the things that makes this area, I think, different than many other areas of the law.
And also somewhat controversial, too, because let's face it, and we've talked with you three, we've talked about this before, is that in one way, obviously you want to serve your client. So your client says, look, we think, and let's say the client is not the elderly person, let's say it's the son or daughter, for example, and they say, look, it looks like mom's going to be going into the nursing home in the next couple of years. We would like to preserve the assets of her estate. Now, you must get that question a lot, correct? Okay?
Well, the issue of who is your client is very important.
Yes. Yeah.
And that has to be established right at the beginning.
Well, who would be, Nancy? I mean, in that instance, let's say...
In our practice,
yeah, we
almost invariably wish for the elderly person to be our client. And if the family member is going to act on behalf of that elderly person, we want to know that the person has authorized it, wants it, and is participating in the process.
Maybe even has power of attorney.
Right. But we want to be sure that the older person is participating in the process of meeting with us to the degree possible, if there's any level of incapacity.
So you make sure and you go to great lengths to make sure that even if the son or daughter comes in, you're talking to mom or dad.
We try very hard to make sure that is what's happening.
Right. Okay.
Mom or dad is the vulnerable adult, and they really need protection. Whereas if we were representing the healthy, vigorous child, they don't need the protection.
Right.
Sometimes the adult needs to be protected from the child. So that becomes our job, too.
Well, in some instances, the son or daughter could be, again, the caregiver, so to speak, could become the adversary. What do you do then?
You have to know who your client is. And if your client is the elderly person, it's very clear what you have to do. You have to protect that person, assist that person, even if it means becoming adversarial with the child.
Okay, where I started with this particular question deals with the nursing home issue. Someone comes into your office and says, we want to preserve assets. In some ways, they're hinting, or they're trying to get around to the point that, hey, we would prefer that the United States government, we would prefer that Medicaid or Medicare take care of mom or dad in his or her latter years. There's maybe $200,000 or $300,000 or $400,000 in their estate now. I'm sitting in front of you, Mr. Crooks, or Ms. Solnick, or Mr. Begley, or Ms. McElnay, and I'm saying, would ask you, okay, so, Attorney so-and-so, how do I go ahead and protect myself? What do I do so that the U.S. government is going to pay this bill and not mom or dad? Now, I'm asking you that in somewhat of a flip manner. I'm not saying that people come in and pose it like that, but you get my drift.
I can respond in part to that, and again, it's all very fact-sensitive. But if someone were to come in, an presently unmarried individual entering a nursing home, they'll only be allowed to have $2,000. In the state of New Jersey, they're really looking for a year to a year and a half of private pay in a nursing home, which is running in our region about $7,500 a month. There's really not going to be a lot to preserve. And one of our concerns, for example, would be that if the parent ever needed to move from one nursing home to another, maybe the child was going to retire in another state, and we would like the best care you're going to get anywhere is if a child or some person is coming in and monitoring that nursing home. We want to make sure, for example, that there is freedom of choice of nursing home. We would want to preserve some funds just so that parent could move to another nursing home if the one they're presently in doesn't work out. So it's not necessarily that there's a greedy child. I have to say, in my years of practice, I have only run into 2 very greedy children.
Interesting. Good
Chris,
point.
I think that implicit in your statement is a misconception that a lot of people have, that people are just motivated by protecting the assets. And there's also a misconception that people with millions and millions of dollars are qualifying for Medicaid. And the truth of the matter is that most clients that come into our office have relatively modest estates, anywhere from $100,000 to $200,000 to $300,000, where they've worked for 40 or 50 years to accumulate this amount of money, and they do want to spend money on the cost of their care. But the prospect of spending down all of their assets, especially when there might be a spouse involved who has no means to then continue to live once the institutionalized spouse may pass on, it's devastating to contemplate that thought. And so they're just looking for a way to protect a portion of their assets.
Well, in a nutshell, how does that work? Let's say one spouse is going to go into the nursing home, and you probably get the spouse who's not going to go into that nursing home, who's panicked, saying, does that mean, that all of the money that I need to live on is going to go to that nursing home as well? All of my assets have to go to pay for my wife who's now going into this nursing home.
Well, there was federal law enacted in 1989, the Medicare Catastrophic Coverage Act, in order to protect the community spouse. And the protections are written into the law, which would allow the community spouse to keep a minimum amount of the funds of the marriage, if I can say that. In addition to which, there are income issues in which the spouse is protected. And at this point in Pennsylvania, we have a particular view of how to value assets, which has become more and more beneficial to the community spouse. So these things have been provided for up to a point under law. I'm not sure that the point that they've been provided up to is really adequate in today's economy in large cities or communities close to large cities. Mm-hmm. But there is a provision.
I think it varies so from state to state. I mean, it's interesting. We're representing here 3 states, and there are 3 different methodologies really of providing funds to the community spouse. In New Jersey, we can give a great deal to the community spouse, really using trusts, annuities.
Yeah. There's 60-some things, planning strategies a married couple can use, 30-some that we use for single people. But most of them revolve around transferring assets to kids, putting assets in trusts, and buying annuities. They're the large ways to save large sums of money. But getting back to what you were saying before about somehow Medicaid planning is immoral or illegal or unethical, we do have a strong tradition of legacy in this country. When we have the federal estate tax law that exempts the first $625,000 of a person's estate from tax, every time somebody utilizes that, it costs the government a little over $200,000. I think it's $204,000, isn't it? Congress last year decided to raise that to $1 million, which will then cost the Treasury $340,000 every time that's utilized. And the clients that come in our office aren't costing the government $340,000. So it's whose ox is being gored, I think.
Good point. Howard,
one comment on this morality issue, which is that New York State has been at the forefront in authorizing what we call Medicaid planning by guardians on behalf of incapacitated individuals. We have had several decisions in New York where the judge has said where the Department of Social Services would object to the proposed planning involving asset transfers, and the judge has said that while we applaud the Department of Social Services' efforts to preserve the public fisc, it's not our job to do that. If the legislature had wanted to do that and prevent this, they would have done it by enacting statutes. And similar to what Tom is saying, you can make these annual exclusion gifts and minimize estate taxes, and that is all very well accepted. And I think just because the Medicaid program is relatively new vis-a-vis estate planning, it just hasn't gotten the same amount of acceptance.
Well, in New Jersey, I know we're going through a major change right now, and then Brenda, I'm going to give the floor back to you, but aren't we going through something in our state where Medicaid benefits and the protection of IRAs is kind of a front burner issue? In fact, it's still in a state of flux, if I'm not mistaken.
Our case has been argued by the Supreme Court, awaiting decision.
End of July.
Oh, okay. Okay. And what is the essence of that
Well, the idea is that the healthy spouse's IRA is an accountable asset or not. Pennsylvania, it's not.
It's
New
not
York,
accountable asset.
And in New York, it's not a countable asset.
So just in New Jersey, it is right now.
Yeah.
That's right.
And
Which, again, is tough on the remaining spouse. I mean, that's
Yeah.
what this is all about.
Sure is.
These people have worked and saved, and they've lived frugally. And
So despite this law, this national law, the federal law you told me about a few minutes ago, Nancy, in a state such as New Jersey, the IRAs would be quote-unquote attachable. Again, one of the spouses goes into the nursing home, and they can delve into those IRAs and take them. But again, that may change.
There are still federal minimums and maximums that are permitted to be retained by the community spouse, and that is federal law. But how those figures are calculated really may be state specific.
You know, before we take a break, we'll try to get to one or two of your phone calls again. We're going to try to get to as many as we can tonight, but again, with so much to cover, we may not get to many of them. Jimmy from New York is up first tonight, from New Babylon or North Babylon, I'm not sure. Howard would know. He's from New York.
North Babylon.
It's from North Babylon. Go ahead, Jimmy. You're on Law Journal tonight. What's your question?
My question is about having a house.
Could you speak up a little bit, Jimmy? We can't quite hear it. We may even need a little audio boost here in the studio. Go ahead, Jimmy. Try again.
All right, hello.
That's better. Okay,
Yeah,
go
you
ahead.
can hear me?
Yeah, we can. Go ahead.
All right, okay, question now. My father's in a coma. He had a bad heart attack, and he's now it's to the point it's been about 3 months. He's into the nursing home, and you know, we don't know what to expect in the future, so we're looking at having the house, because he has no will or nothing, being put into my mom's name at first, and then eventually maybe get into the kids' names. And the question, maybe if you guys have like maybe some advice, you know, the best way to go about it.
I'm sure they do, and of course, I think this is probably a good example of how you often see potential or prospective clients. It's when an emergency or a crisis happens, and that's why tonight, and we're going to help you out here, Jimmy, but that's why tonight we're talking about proactive elder care planning, getting things done way ahead of time so you're not faced with this situation when dad or mom has a heart attack. Go ahead first, Howard, since you're from New York.
Okay. First, the thing that you should know is that the house is a protected resource, not only in the tax laws, but in the Medicaid laws as well. So that it is not counted for purposes of determining your dad's Medicaid eligibility. If you wanted to transfer the house to your mom, you could do that, and that would be an exempt transfer, meaning that it would not result in a penalty period for dad's eligibility purposes. And in addition, you could then effectuate a transfer to the kids. But the one thing that I would point out is that with all of these transfers, there are tax considerations that have to be dealt with as well. But there is a means to protect this asset.
First question that we need to have the answer to is there a power of attorney under which this transfer can take place? Because if the house is titled as a tenancy by the entireties in the names of both father and mother, you have to have your father's signature or the signature of someone who's legally permitted to sign for him. If there is no power of attorney, then, and you want to do this transfer, a guardianship may be required.
Yeah,
so there are some
especially in this
concerning
state.
issues here.
Yeah, right. Absolutely.
Let me
In New
just
Jersey, there's another issue, and that is that there would be a state recovery if dad died owning the house with mom.
Pennsylvania as well.
Pennsylvania as well, but not in New York.
Not in New York. As long
Yeah.
as there's a surviving spouse in New York, there is no estate recovery on the house.
Well, the estate recovery only applies to probate assets in Pennsylvania at this time.
Okay.
So if it's jointly held between husband and wife, that would not be recoverable under estate recovery in Pennsylvania.
Okay, but what you're saying, Howard, in a nutshell, is for Jimmy, he really should sit down with an attorney. There's still maybe something he can do at this late hour to preserve some of these assets.
It sounds like he's going to have to go through the guardianship court to get a judge to authorize this asset transfer.
All right. Hey, Jimmy, good luck to you. A couple of things we're going to take a quick break, but first we want to remind you we're running a survey tonight, so vote early. And here is this week's Law Journal survey question. As an elder person, do you believe that your caregiver is handling your legal and business affairs properly? Are you satisfied? Vote by dialing toll-free 1-888-869-8683. Press 1 for yes, 2 for no, and 3 for undecided. And we want to remind you folks, this or any Law Journal program we do here, if you'd like to pick up a VHS copy of tonight's program, or if you'd like to contact us, if you folks have that other survey, if you have our second billboard in there, Jason or Bob, if you don't, we're going to just pass on that, and we'll get to it in the second half of the program. Tonight we're discussing, there we go, toll-free, 1-888-78-LAW-TV, if you've got any questions, comments, you'd like to request a VHS tape, or you can visit our website at www.lawjournaltv.com, or email us at lawtv98@aol.com. Again, I'm with 4 attorneys who have dedicated and are dedicating their professional lives to the practice of elder law. I'm attorney Christopher Naughton. We'll be back with more of your questions and comments in just a minute.